Welcome to This Explainer. Today, we're diving into a piece of Indian legislation that absolutely transformed how disability is treated under the law, the Rights of Persons with Disabilities Act 2016. For decades, millions of Indians living with disabilities were met with laws that frankly offered little more than sympathy. But this act, it completely rewrote the rulebook. It shifted the entire landscape from a welfare-centric approach to a rigorous, rights-based ecosystem. So whether you're an employer, a student, a public official, or just an informed citizen, understanding the mechanics of this legislation is absolutely crucial. Okay, let's dive into this. The contrast between the old 1995 framework and the 2016 legislation is pretty stark. Under the old law, only 7 conditions even counted as disabilities. The 2016 Act expands this dramatically to 21 recognized conditions. We're talking about including things like autism spectrum disorder, specific learning disabilities, and acid attack victims, with the power for the government to notify even more in the future. We also see government job reservations bumping up from 3% to 4%. But the most vital shift here isn't just about the numbers, it's the paradigm itself. We're finally moving from a system of charity to a system of enforceable, hard legal rights. To navigate this massive shift, here's our roadmap for the explainer. First, we'll explore that rights-based paradigm, then define benchmark disabilities, map out the core rights, walk through a practical compliance checklist for organizations, and finally, look at how the law is actually enforced. Basically, we're bridging the gap between individual empowerment and organizational accountability. Let's get right to it. Section 1, a rights-based paradigm. Before we get into the heavy legal mechanics, we really need to understand the historical context, because the why behind this law matters for every single one of us. Now, this transformation didn't just happen overnight. While that outdated 1995 Act limped along for years, the real catalyst hit in 2007 when India ratified the UN Convention on the Rights of Persons with Disabilities. That international commitment essentially forced a complete overhaul of domestic policy here. Parliament eventually passed the RPwD Act in 2016, and it officially came into force on April 19, 2017. This timeline represents a major awakening, recognizing that it's the societal barriers, not just physical impairments, that truly define disability. Moving right along to Section 2, defining benchmark disabilities. To fully grasp the rest of this explainer, we need to quickly review the legal lexicon. First up, a benchmark disability. This means a person has at least 40% of a specified condition, as certified by a medical board. Now, you might be wondering, why does this 40% threshold matter so much? Well, because it is literally the key that unlocks the major statutory benefits. Without meeting this specific mark and getting your unique disability ID, or UDID, individuals just can't access crucial reservations, educational quotas, or specialized government schemes. It is the practical starting point for claiming your rights under this law. And this brilliantly illustrates how the law levels the playing field through reasonable accommodation. This is not about giving someone an unfair advantage. It's about ensuring true equality. It means making necessary modifications. Think adjusting working hours, providing screen reader software, or maybe modifying a physical workstation, as long as it doesn't impose a disproportionate burden on the provider. Under this act, denying a reasonable accommodation isn't just frowned upon, it's legally classified as discrimination. Our third key term is limited guardianship. The old legal model relied heavily on blanket guardianship, which effectively stripped persons with disabilities of their decision-making power entirely. Well, the 2016 Act throws that right out the window. Instead, it introduces limited guardianship, where a guardian and the individual make decisions jointly, based on the person's actual evaluated support needs. It's an incredibly progressive shift that deeply respects personal autonomy and perfectly aligns with international human rights standards. Okay, Section 3, core rights and entitlements. Now that we've got the terminology down, let's look at how this law actually empowers everyday lives. Let's start with a very important number, 5%. The law mandates a minimum 5% reservation of seats in all government and government-aided higher education institutions for persons with benchmark disabilities. This is huge because it ensures that the doors to higher learning and skill development remain firmly open. And here's our next big number, 4%. This represents the minimum reservation in vacancies for government establishments. And, Indian courts have made it crystal clear that this reservation applies horizontally across categories. This isn't just some vague promise on paper. It is a direct, legally guaranteed pathway to employment and economic independence. Beyond just education and jobs, The Act guarantees sweeping everyday entitlements. We are talking about strict non-discrimination under Section 3, free education for children with benchmark disabilities between the ages of 6 and 18, mandatory barrier-free access, and this means not just physical spaces like parks and buses, but also digital spaces like government websites. It ensures priority healthcare access and mandates state-level social security schemes. I really want you to remember this. These aren't just aspirational goals drawn up in some committee room. They are legally enforceable rights. Which brings us to Section 4, the Organizational Compliance Checklist. If you happen to be an HR professional, a business owner, or part of a government entity, this section is definitely for you. Because let's be honest, it's not enough to just say you're an equal opportunity employer. You have to prove it. For physical infrastructure, organizations need to actively audit their spaces and create time-bound remediation plans. For recruitment, you must strip away those indirect barriers, like demanding a random physical fitness test for a desk job. Over in the digital realm, you've got to test your internal software and public websites for screen reader compatibility. And for reasonable accommodation, you must document every single request and its outcome. Embedding these actions into your daily practices, that is what true compliance looks like. Furthermore, the Act explicitly lays out mandatory duties. Every employer must frame and register an equal opportunity policy. You have to maintain strict structural records, appoint a liaison officer specifically for grievance redressal, and, like we just discussed, provide reasonable accommodations. So the crucial point is this. Ignoring these duties is simply no longer an option. Failing to comply brings some very real legal, financial, and reputational risks to both private and public employers. Finally, Section 5, Enforcing the Law. Having rights on a PDF is great, but how do citizens actually hold these institutions accountable in the real world? Let's move to the escalation ladder and see how this builds. If a right is denied, a citizen doesn't have to jump straight into an expensive years-long civil court battle. Step 1 is simply gathering evidence. Think disability certificates or emails denying an accommodation. Step 2 is approaching the institution's internal grievance officer. If that goes nowhere, Step 3 is filing a complaint with the state or chief commissioner. They actually have powers similar to a civil court and can issue binding directions. And Step 4, for severe offenses or atrocities, the Act mandates district special courts to ensure speedy trials. To really bring this to life, let's look at 3 quick, real-world scenarios. Say a highly qualified candidate in a wheelchair is rejected for a job solely due to their mobility. They can escalate this directly to the company's liaison officer. What if a school claims they lack the staff to admit a child with autism? The parents can approach the commissioner, who can literally force the school to comply. Or, say a municipality builds a beautiful new park, but completely forgets the wheelchair ramps. Citizens can file a formal complaint, and the commissioner can issue a binding direction, forcing the city to retrofit the space. This is the law actually working, resolving everyday issues and enforcing equality. And make no mistake, this law has teeth. Chapter 16 of the Act explicitly criminalizes abuses. Intentionally insulting or humiliating a person with a disability in public, that can lead to imprisonment and hefty fines. Conducting medical research on a person with a disability without proper consent carries incredibly stringent punishments. And of course, to protect the integrity of the whole system, making fraudulent claims to steal disability benefits is heavily penalized as well. The legislature designed this to deter systemic discrimination at every single level. As we wrap up this explainer, I want to leave you with this final, provocative thought, especially for the leaders, the educators, and the employers watching today. Is your organization truly building an inclusive environment, or are you simply doing the bare minimum just to dodge legal penalties? The Rights of Persons with Disabilities Act 2016 gives us the legal blueprint for equality for sure, but the spirit of the Act challenges us to go further, to see inclusion not as some compliance checkbox, but as the foundation of a genuinely better society. Thank you so much for joining me, and keep questioning the structures around you.